Does the alphabet soup of US privacy law have your head spinning? Yeah, me too sometimes. But don't worry, let's tackle this ultimate exam review session together. Today on The Explainer, we're going to distill this incredibly complex ecosystem of rules, regulators, and enforcement actions into the absolute core concepts you actually need to know. If you want to ace your understanding of the US private sector privacy landscape, well, you are exactly where you need to be. So grab your notes, because we are going to move fast and cover a whole lot of ground.
Okay, if there is literally one core concept you must remember to set up your whole mental framework, it's this. The United States does not have a single comprehensive federal privacy law. What we have instead is a giant, complicated patchwork. To really master this topic for the exam, you've got to understand how overlapping federal laws, state laws, and even self-regulatory enforcement all kind of crash into each other. It's not just one neat rulebook, it's dozens of them layered on top of each other. So here is our exact syllabus for today. We're looking at types of enforcement, the mighty FTC, federal sectoral laws, state-level privacy enforcement, and finally, self-regulation and privacy.
All right, part 1, types of enforcement. Let's get right into it. Before we start naming specific laws, we need a really solid foundational understanding of how privacy violations are actually pursued legally in the US. This is super high-yield exam materials, so lock this concept in your brain. You absolutely must be able to contrast these 3 distinct enforcers. First up, civil litigation. This is just between private parties, usually where a plaintiff is trying to get a monetary judgment. Contrast that with criminal prosecutions. These are brought by government heavyweights like the Department of Justice or state attorneys general, and they can actually put people behind bars. Finally, we've got administrative enforcement. This is carried out by government agencies, think the FTC, and it usually results in cease and desist orders or big civil penalties. Knowing exactly who brings the action and what the penalty can be, absolutely crucial.
Moving right along to part 2, the mighty FTC. Now, because we don't have that one single data protection authority, the Federal Trade Commission is widely considered the ultimate lead privacy enforcer in the US. And here is a massive vocabulary spotlight for your flashcards, the consent decree. You need to know this term inside and out. The vast majority of FTC enforcement actions end right here. It's basically their go-to mechanism to settle cases. The catch? The company doesn't technically admit they did anything wrong, but they promise to fix their practices. And here's the real kicker. They usually have to submit to strict outside audits or adopt comprehensive security programs for like 20 years. It is a massive ongoing compliance burden. Now, here's a really testable matchup. You need to compare the 2 main prongs of Section 5 of the FTC Act. The FTC goes after unfair or deceptive practices, but you've got to be able to tell them apart. A deceptive practice is essentially all about broken promises. Like if you say you won't sell user data in your privacy policy, and then you just go ahead and sell it anyway, that's deceptive. Unfairness, on the other hand, is a whole different beast. It doesn't even require a broken promise. It's about causing substantial, totally unavoidable injury to consumers that just isn't outweighed by any countervailing benefits. Unfairness is a much stricter 3-part factual test, so keep that straight. All right, pop quiz time. Let's test your knowledge right now with a quick flashcard check. Based on some recent, genuinely groundbreaking FTC enforcement actions, specifically that crazy case against the photo app Everalbum, do you know what algorithmic disgorgement actually means? Take a second, think about it. Okay, so the crucial point here is that penalties are evolving fast. In the Everalbum case, the company was deceptively collecting facial recognition data. But the FTC didn't just slap their wrist and say, delete the data. No way. They forced Everalbum to literally destroy the facial recognition algorithms and the underlying models that were trained on that ill-gotten data. This completely changes the game, proving that FTC penalties now go way beyond just monetary fines. They can target the actual intellectual property a company spent millions building.
Okay, on to bucket number 3, federal sectoral laws.
For ultimate exam cramming, you really have to remember that the US relies heavily on these sectoral laws. Basically, you need to play a matching game, connecting specific sectors to their respective laws and agencies. Medical data, that's covered by HIPAA and HITECH. Financial data is governed by the GLBA and the Fair Credit Reporting Act, or FCRA. And notice something really important here. Look how often the FTC overlaps with specific targeted agencies like the CFPB in finance or the FCC in the telecom space. Seriously, the FTC is literally everywhere. Let's zoom in on one of those major federal sectoral laws in action. CIPPA, the Children's Online Privacy Protection Act. This is a huge testable area.
Under COPPA, the FTC stringently regulates children's data. For the exam, memorize these core mandates. It applies specifically to kids under 13. It requires highly visible, functioning links to privacy policies. And, most importantly, it strictly mandates that operators obtain verifiable express parental consent prior to collecting any data. Not after, prior. Let's shift gears to Part 4, State-Level Privacy Enforcement. Honestly, if you think the federal government is complicated, wait until we look at the states. It is a fundamental concept to grasp just how much baseline power the states hold. Every single state empowers its attorney general to act as their primary privacy enforcer. And look at the uniformity across the board. All 50 states have their own unfair and deceptive acts and practices, or UDAP statutes, which basically mirror the FTC's rules. All 50 states mandate rapid data breach notifications, and all 50 have specific identity theft laws. The states are an absolute force to be reckoned with. On top of that, by the end of 2022, California, Colorado, Connecticut, Utah, and Virginia led the charge by enacting their own comprehensive privacy laws. But here is the highly testable concept you need to know about these states. Notice how they deliberately interact with the federal laws. They feature very specific exemptions, either at the entity level or the data level, for information that's already regulated federally, like under HIPAA or GLBA. They did this specifically to avoid double regulating your medical or financial data. And finally, Part 5, Self-Regulation in Privacy. You know, sometimes the government actually isn't the one writing the initial rules. Let's look at the incredibly wide spectrum of industry self-regulation. On one extreme, you have PCI DSS. That's the Payment Card Industry Data Security Standard. This is a super strict, highly enforceable security standard. If you process credit cards and you fail your third-party assessments, you are facing massive fines, like up to $100,000 a month, or you just get kicked off the network entirely. Contrast that heavy hammer against the Digital Advertising Alliance, or DAA. This is a totally voluntary coalition for online behavioral advertising. They use that little Ad Choices icon program to inform consumers and offer opt-outs. So both are forms of self-regulation, but obviously they have vastly different teeth. Okay, to really synthesize everything we've learned today about this crazy overlapping ecosystem, let's look at the climax of the 2016 Uber data breach. This is the ultimate case study. Hackers breached over 60 million records. Uber's security team amazingly tried to cover the whole thing up by paying off the hackers with a $100,000 ransom and hiding it from the FTC. Well, that triggered a massive cascade of overlapping enforcement. Uber faced administrative consent orders from the FTC for failing to secure the data and unprecedented criminal convictions when their former security chief was actually found guilty by a jury of obstructing the FTC. Or if you want another completely jaw-dropping example of overlapping enforcement, consider the 2017 Equifax breach. Because of their massive security failure, Equifax didn't just face one angry regulator. They faced an astonishing $300 million settlement fund that was pursued simultaneously by the FTC, the CFPB, and 50 state attorneys general. Basically, when you mess up privacy at scale in the US, the whole alphabet soup comes knocking at your door. All right, to wrap up this explainer, let's test your overall comprehension of the U.S. framework with one final mock exam question. Imagine a health app deceptively shares its users' data. Based on everything we literally just covered, which enforcers could potentially take action against them? Have your answer ready? Because the U.S. lacks one central privacy law, the answer is a combined swarm. You'd absolutely see FTC administrative action under Section 5 for deceptive practices. You'd have 50 state attorneys general stepping in using their state UDAP laws, and you'd potentially see civil lawsuits from private citizens seeking monetary damages. The whole shebang. As we review our notes today, it really leaves us with a final provocative thought. As artificial intelligence and all these new technologies rapidly evolve, is this highly complex, overlapping patchwork system actually sustainable for the future of privacy? Keep that question rolling in your mind as you prep for the exam. Good luck.